Hello, this is Rich Klein from the Diamond Law Group. Today, what we're going to cover as part of our 1-hour continuing education for real estate agents here in the state of New York is the residential proposed contract for a 1 to 4 family home. There's a separate contract for co-ops and condos. However, today we're just going to cover a freestanding 1 to 4 family home. And when we're going to go over that, I'm just going to show you that it's a boilerplate form. I go to this website, judicialtitle.com, and you just simply scroll down for residential contract to sale. Going to download the actual contract itself. Just to show you that it's a boilerplate form that we're going to be going over today. There's no hidden language. There's no secrets here. And we're going to cover everything you need to know as if you were the client in a contract signing to purchase or sell this home. So right from the beginning, we see up here that this document itself was drafted as part of a joint effort between the Bar Association and other real estate committees. Moving right along, it says consult your lawyer before signing this contract. Obviously, we would strongly suggest doing that. So, right off the bat, they like to talk about all this wonderful stuff. They talk about fire and other loss due to condemnation. There's other laws that will apply if, God forbid, knock on wood, that happens to the property in the midst of your transaction. Talking about more pleasant things here, we date the contract. That's the date that the seller signs the contract and sends it back to the buyer's attorney. It's not the date that the buyer signs. The parties are not fully in contract until both parties have signed and the seller's attorney has received the down payment funds via check or wire. So we're then going to be adding the seller first. You don't necessarily need to add the social security number. That's not really done in practice nowadays. In New York City, we have a certain type of transfer document known as ACRIS. You may want to do so, but for the most part, this contract was drafted so long ago when cyber fraud wasn't really as prevalent and it wasn't such a big deal. But nowadays, most parties don't include their social security number on the contract. And then we're going to add simply the purchaser's name. The purchaser's name should really reflect the way in which title will be held. And that's also dictated by how they apply for their loan. So in other words, the contract should match the loan application, which is going to eventually match the deed at closing. Everything should be the same up front. So for instance, my name is Richard, but I often go by Rich. However you want to be reflected on title should match the purchaser's name. Going back to the seller's name, it really should also match how the last deed of record was held. If you don't have that at your disposal when the attorney's drafting the contract, that's relatively okay because we could always fix that problem once we receive the title report through what's known as an AKA affidavit. So for instance, if I sign the contract as Rich, but I took title as Richard, I would just sign an affidavit that I'm also known as one name or the other. But having the deed beforehand to draft the contract would be extremely helpful for the seller's attorney. Moving right along here to paragraph 1. This is where we're going to be identifying the property. It says over here, Schedule A. That's something that is attached to the deed, the deed of record from the title report at that time. It would be super helpful if the seller's attorney had that as well, though it's not required. Some attorneys will hold up the signing of a contract. It's not necessarily required, but it would be extremely helpful. The street address is the postal address, which is the most commonly used address. However, that may differ than the actual address. So for instance, our office here in Massapequa Park is really in Massapequa. We are not in the village of Massapequa Park. However, the post office route that we are on is Massapequa Park. So that's what we go by. The tax map designation, this is also known as the section block and lot. That's really what you're actually purchasing, because of the street address may differ than the postal address. The tax map designation is the best way to identify which property you're buying and selling. And again, if you don't have that prior to, that's okay. Relatively, we would prefer to have it, but if not, it's not the biggest of deals. Moving on to this little subparagraph here, it says that the seller may own portions of the street or the sidewalk, and it's their responsibility to maintain that as well. And it's included with the sale of the home. Moving on here to paragraph 2. This is dealing with the personal property, specifically the way the boilerplate contract is drafted. It states that everything that exists at the property, some of these items may not exist. For instance, you see a weather vane and TV aerials. These things aren't very commonplace nowadays. If they exist at the property, then they are deemed to be included with the sale of the home for no additional money. It's important to note that when a lender looks at this contract, the money that they are lending is based upon the actual property itself, the real estate property, not any personal property. That should be handled outside of the contract, which is something we'll discuss later on. But for our purposes now, this is everything that is included. As part of your listing, if the seller's taking any personal property, such as something that has sentimental or financial value, that should not only be listed on your listing itself, perhaps on the broker remarks, but also specifically stated in the contract itself, right in this subparagraph right over here. If it's a fixture or other appliance, it'll usually need to be replaced by what's known as a builder's grade fixture. And this is where some parties, during the course of the transaction, have misunderstandings about what's included and excluded. When in doubt, you should specifically exclude it from the beginning so as to avoid any miscommunications. Next, purchase price. So right here, we would enter the purchase price, and over here, we would enter the down payment. The problem with the down payment is there's 2 portions of the down payment potentially. One is at contract. That's what the buyer would send to the seller's attorney to be held in the seller's attorney's escrow account at the time of when they sign the contract. Then there could be a portion that is due at closing. So for instance, if our client was purchasing for $1 million and taking out a loan for $800,000, they would be financing 80% of the transaction and putting down as the quote unquote down payment 20%. However, at the time of the contract signing, they would only put 10% down at contract. The balance of the 10% would be due at closing. It's very important to note on your sales agreements or binders, or however you want to phrase that document, when you send that over to the attorneys, that you indicate how much is due at contract and how much is due at closing. Because if you send over a sales agreement, for my example, that specifically says you're putting down $200,000, the seller's attorney doesn't know any better and will put that down as the down payment. Then I, as the buyer's attorney, would say, no, we're only putting down 100,000. And then the seller doesn't understand what's happening. They think that the buyer's trying to put down less than they originally agreed to, when in all actuality, they're not. The financing percentage is still staying the same, but it's just less due at the time of actual contract itself. And that's where we would see that right over here. The balance due at closing would be in certified funds, and we'll discuss that later on, but this is where the balance due at closing would go. And sometimes that trips people up, because if you put $1 million here and 100,000 here, the balance due at closing would be 900,000. However, when we scroll down later to the mortgage contingency, that would say 800,000. And the question is, well, where did that extra $100,000 go from what's due at contract compared to what's due at closing? And the answer is the contract doesn't specifically say that. It doesn't say if you're buying for $1 million and you put down 100,000, that there's another 100,000 due at closing. It just doesn't say that. It just says the balance due at closing right over here. All right. Next, for paragraph 4, this doesn't necessarily apply nowadays, back in the day when you used to have a local community savings bank and everyone knew everyone else, the buyer might actually be able to take over the existing loan from the seller. That is very rare nowadays. However, it's still part of the boilerplate contract. Paragraph 5, purchase money mortgage. This is not all too common either, but this is where the seller would be giving the buyer a loan themselves, and the buyer would not be receiving institutional financing. Moving on to paragraph 6, this has to do with where the down payment will be held, and it's going to be held over here. It says in an IOLA account. That's done for the protection of the buyer, in that the money cannot be used for the seller's attorney's personal purposes. It also goes on to say that the seller's attorney is just a stakeholder and they have no determination as to whether or not they can lease the money of their own accord. So what happens is, if there's some type of dispute between the parties and the sellers say to their attorney, well, you're the escrow holder, I want you to release the money. The seller's attorney, as the escrow holder, can actually not release the money unless both parties agree to that fact. All right. Usually the money will be held in a non-interest bearing account. Sometimes with new construction, the money will be held in an interest bearing account. But of course, if you're in interest, you have to pay taxes on it. And by the time you're done with that, it's not necessarily all too much. The type of funds that can be payable at the time of closing or under the contract, it's cash, but not over 1,000. Very frequently, you'll see that for oil adjustments. You'll notice on here, it doesn't say anything about Venmo or anything like that. This contract is well before that type of technology was available. For the most part, it needs to be certified funds. Believe it or not, when you talk to some clients, they've never written a check before. So when you say you need to bring a check, a certified check to closing or a bank check to closing, they actually just bring their regular personal checkbook, because they don't know that there's a specific type of check that you actually have to go to the bank and ask them for. So we always like to make sure that they understand that it's a different type of check. It's not a personal check. All right. So next, moving on to what's one of the more important contract provisions here, and that's the mortgage contingency. So even though on the boilerplate form over here, there's a little typo, what it says is that you must secure a mortgage commitment on or before typically 30 days, sometimes 40 days. However, that date doesn't start to run until the parties are in contract. And again, you're not in contract until both parties have signed and the seller's attorney has received the down payment check. It then goes on to say the amount. Okay, so from our example before, this is where the $800,000 would go. All right. You can apply for less. It just says that this is the cap. All right. It also limits in the boilerplate contract the type of financing you can apply for. This says you cannot apply for VA or FHA financing, because at the time of this contract, those types of finances weren't really all too prevalent. Nowadays, it's very important when you're reviewing this with your clients, if they're applying for FHA or VA financing, that they need to strike this provision from the contract. Otherwise, they would be deemed to be in default. All right. Next, moving on in this contract, it says here that the contract is subject also to a satisfactory appraisal. However, the appraisal contingency is a separate class that we have actually already filmed and that will release soon enough. And there's a whole long list of things you need to know about appraisals. However, it does say in this contract that it is subject to a satisfactory appraisal. Part of the complicating factors is some banks will still lend to the buyer, even though the appraisal came in short, and that sometimes trips up the parties as to who has to do what. But however, this is where you're going to find in this contract that it is subject to a satisfactory appraisal. Okay, so another important thing to take into consideration in this contract is that the buyer, if they intend to cancel, has to do so within 5 business days after the contingency date. Otherwise, they're deemed to be in default. So if they have not secured a mortgage commitment on or before the required time frame, then the buyer's attorney must make a timely request for an extension or give notice that they're canceling due to that fact. How it says here further, if the purchaser fails to give notice of that commitment date, then they're actually deemed to be in default or have waived the mortgage contingency. So it's very important to keep on track of all of these dates within the contract in order to make sure that the buyer is not accidentally deemed to be in default, because that could actually jeopardize their down payment. All right. So moving on to the next paragraph, it's permitted exceptions. These are items that the buyer is actually taking the property subject to. It's for certain things such as zoning and subdivision laws, historic wetlands designations, provided that the property could be used for its intended use as, let's say, a one-family dwelling. It says encroachments of stoops and other items. That's okay, relatively, provided it's not in excess of 1 foot. That's another separate class that we teach about surveys and certificate of occupancies. The variations for property lines is deemed to be 1 foot. That's acceptable by title companies. Anything in excess of that would be uninsurable. So paragraph 10 also talks about violations. The seller has to convey the property free and clear of all liens and judgments, violations, things of that nature, as per the boilerplate contract. Seller representations that they have right to access a public road. If that's not the case and it's a private road, that should be indicated here. This says that the seller has the right to sell the property. The seller is not a foreign person, otherwise they need to provide a FIRPTA. It's the Foreign Investment Real Property Tax Act. They have to provide this form at closing, because the presumption is if the seller is not a foreign person, or sorry, is a foreign person, that they're not going to stick around to pay their US IRS taxes. So that would actually be something the buyer would be responsible for. So it's important to get that affidavit at closing if you don't believe that the seller is a foreign person. Next, and then if there's any AKAs, that way we could search. Sometimes if someone in a relationship has had a maiden name, you would reflect that here to make sure that there's no liens and judgments against them. And then it also says here that unless otherwise specifically stated, the contract itself is extinguished at closing unless it specifically is stated to survive the closing itself. All right. Next. So in paragraph 12, let me just go back to paragraph 11. It also states something about taxes and things of that nature that they have been entitled to. So that has to do with STAR, veteran exemptions, and things of that nature. All right. So you would specifically state anything that was out of the ordinary in paragraph 11, but usually the STAR exemption and things of that nature are what holds true. So moving on to paragraph 12, this is also an important contract provision. It says here that the purchaser is fully aware of the condition and state of repair of the property. That's basically in essence saying you either conducted a home inspection or you didn't, but it's up to you to familiarize yourself with the condition of the property. And it also goes on to say that the property is being sold in its as-is condition, subject to reasonable use, wear, tear, and natural deterioration between the date of the contract and the date of closing. That's why the buyer is also going to be conducting, over here it says, their authorized representatives shall have the right at reasonable times and upon reasonable notice to inspect the property. That's where the walkthrough provision comes in, right here, that the purchaser is entitled to access the property to make sure that nothing has befallen the property in terms of how it's been damaged from the time of contract through the time of closing. As is relative. Some sellers say everything's as is. Yeah, it's as is, but as it is when the buyer made their offer. If something happened to the property and something's no longer working, then the seller still has an obligation to make sure that it's still in the same condition it was when the buyer made their offer. They can't throw their hands up in the air and say it's as is if something has actually happened. And then over here it says, except as set forth in paragraph 16F. We'll talk about that later, but that talks about the systems of the home itself that specifically need to be in working order. Paragraph 13 talks about insurable title as differentiated from marketable title. Insurable title is what we convey here in the state of New York, because marketable title would be somewhat impossible. The covenants and restrictions that we talked about earlier about utility easements and things of that nature, those are insurable issues, because the title company is saying, well, these utility companies have the access to the property, that's okay. Marketable title would be that there would be no issues whatsoever. No one would have access to the property. It'd be 100% the seller's right to sell the property. And that's just simply not the case. There's always going to be utility easements, especially here in New York. So that's what insurable title is. And that's what we convey here. All right. Paragraph 14 talks about the type of deed. The very vast majority of the time in the state of New York, you're going to see a bargain and sale deed with covenant against grantor's acts. And what that means is that the seller is stating that they have the right to sell the property, as compared to a quit claim deed, which is saying that the seller may have the right to sell the property. That just doesn't happen all too often. Upstate, you'll see something known as a warranty deed. And a warranty deed is a little bit stricter than what we use down on Long Island. And that's because the buyers and sellers attorneys themselves do the title searches, and they then have the seller's warrant that everything's okay. Downstate, we use title companies, which is ensuring the transaction. So the type of deed that we use in conjunction with the title insurance gives the buyer every assurance that they need. It also says here that if there's some type of corporation, that they will have the corporate consent in order to convey the property to the purchaser. That's in paragraph 14. Paragraph 15 is always fun. So this is where a lot of people say, well, you know, the on or about date, this talks about closing dates. The on or about date's real estate law in New York. It's just not. It's just common practice. This is where you would put in the on or about date. Again, commonly, we say it's 30 days, but that's not a law. It's done by a reasonable standard. And if it ever gets in front of a judge or jury, they're going to just determine what the party's intent was to close. So if it's been made very, very, very clear that everyone wants, or the one party wants to close before a certain date, and they don't, and that party sues the other one, they may take that very strictly, even though it says on or about. Okay. So there's something known as a time is the essence closing. These standard provisions don't reflect the time is the essence closing. That really gives everyone the indication that you must close, otherwise you will be deemed to be in default. It's very rare that that happens in a regular standard residential transaction. It says that the office of, it really should be either in the seller's attorney's office if there is no financing involved, or at the lender's attorney's office if there is going to be a mortgage involved. However, it should go on to say that it should be closing in the same county within which the property is located. That's not to say that, let's say Amityville, which is on the Nassau-Suffolk border, is anywhere near Montauk. So it's all a reasonable standard that should be laid out beforehand. If the parties want to retain a Manhattan attorney and the property is on Long Island, there's no reason for everyone to go into Manhattan. So it's an important provision to pay attention to. All right. Paragraph 16 actually has a lot of important provisions, which we're going to go through shortly. So paragraph 16B talks about certificate of occupancies. The boilerplate language specifically says that the seller is going to provide a certificate of occupancy, commonly abbreviated as CO, or a certificate of compliance. These things are all synonymous with one another, for the entire house, covering the buildings and all improvements, authorizing the use as traditionally a one-family dwelling at closing. However, the vast majority of the properties on Long Island, if not all of them, have something that is probably not up to code as far as the building department is concerned. So that's why you'll commonly see attorneys carve out specific exclusions, such as garage conversions, finished basements, second kitchens, hot tubs, decks, porches, things of this nature. And the parties should discuss any potential CO issues up front, so that way they're tempering their expectations. There's a couple of concerns. The buyers themselves may want everything, the buyer's attorney, the buyer's bank, if involved. So it's important in this paragraph that if there's CO concerns, that the parties disclose that up front. Otherwise, you're going to get into issues that are going to potentially delay the transaction, or worst case scenario, cause the cancellation of. Again, we're going to have a separate class that talks about surveys and COs, where we will elaborate on how that functions within the New York State contract. All right, paragraph 16C talks about if there's any type of gains within the property, but traditionally that's not generally the case anymore. They did away with that. So again, the FERPTA comes up here, and it actually says that if the purchaser does not have this, it's subject to potentially penalties on behalf of the buyer to have to pay, because the seller fled the country and didn't pay their fair share to New York State. So again, it's important that if you're concerned about whether or not the seller is a US citizen and not a foreign person, that you obtain that up front. Otherwise, the IRS is going to ask the buyer to pay whatever the seller should have, which obviously would be extremely unfair. I'm going to talk next about 16E. This says that the property needs to be broom clean, condition and free and vacant of any leases or tenancies. So if there's going to be somebody who's remaining within the property, that should be handled via separate rider. All right, but it needs to be broom clean. Broom clean is defined as what literally you take a broom and anything that could not be swept away must be removed from the property. Paragraph 16F, again, we talked about earlier when we were talking about paragraph 12. This says that all plumbing, which includes any water or septic systems, heating, air conditioning, electrical, mechanical systems, which is pretty vague. A lot of things could be considered mechanical, such as sprinkler systems or pool systems, and machinery within the property, plus all appliances need to be in working order as of the date of closing. So if there's any issues whatsoever, that should be discussed up front, because otherwise the parties again get bent out of shape. Some attorneys will add the roof or potentially the basement free of leaks. They'll also add limitations to the appliances not being in working order. You'll see $100, $200, depending on the type of property. And if it's concerned regarding the pool, the sprinklers, potentially you'll put in here that escrow can be held. Sellers or sellers attorneys usually frown upon that, and they'll suggest that a closing letter from whatever company winterized the properties may be able to be used instead. Next, it says that there's a working smoke detector within the property. And next, that there'll be, if there's any affidavits from the title company, that they'll be signed as well. Moving on to paragraph 17, this talks about the transfer tax. It says that the traditionally the seller will have to pay what's known as a transfer tax. So in New York State itself, that is calculated on the document itself, known as the TP 584, as $2 per 500. The easiest way for you to calculate, if you want to tell your sellers what the transfer tax is, just take the purchase price and divide by 250. That's the easiest way to do so. In here, it also goes on to say that the appropriate party, again, it doesn't specifically say the seller, but that's just done by tradition. All right. There are some examples of where the buyer would pay the transfer tax, such as for an REO or foreclosure transaction, or potentially for new construction. But usually the seller will have to pay the transfer tax. If you're in New York City, there's a varying scale of transfer taxes. For instance, it's under 500,000. It's at least 1% of the purchase price. There's other types of transfer taxes. There's a mansion tax, which traditionally is 1% over $1 million. There's also a Peconic tax, which you're going to find in the Hamptons areas, that the buyer has to pay unless they're exempt for income or first-time home buyer exemptions. Next, paragraph 18 talks about tax adjustments. The tax adjustments are somewhat convoluted, especially here in Nassau County. There's traditionally two different taxes unless you live in a city or village. There's the town and the school. And this is where the tax adjustment provision comes into effect. I'm not going to go over the taxes now because, again, we have a separate course for calculating closing costs, which will elaborate on that. But here, this is where we say that anything the seller's prepaid would be adjusted in their favor. And if they have not, then the buyer gets a credit for that. It also goes on to say if there's any fuel, such as oil or propane, then that is not included with the sale of the home. It's not like when you buy a car and the gas is included. This is totally separate. That's deemed to be a commodity. The purchaser is entitled to a final meter reading conducted within a close proximity to when the actual closing is itself. And it should state how many gallons are left and how much it paid per gallon. All right. It says if there's any errors or omissions, that could be corrected after the fact. Sometimes that'll happen with water meter readings. Some parts of Long Island, the water is very cheap. If you're in the boroughs, the water is a little bit more exorbitant and you need a final meter reading because water is one of the few utilities that actually remains with the home. And if the seller doesn't pay it, the buyer would then see that on their next bill. So paragraph 19 talks about taxes as well. So in Nassau County, by way of example, the taxes, let's say for the first half, start to run July 1st. Again, the first half of school taxes in Nassau County start July 1st. But you say, well, Rich, when is that tax due? Taxes actually due October 1st. And it's not like it usually comes out October 1st, even though that's the deadline. There's traditionally a 40-day grace period, which runs through roughly Veterans Day around November 10th. So this paragraph says that if that's the case, we can use whatever taxes are available at that time. If the taxes, if you close in August, you're not necessarily going to know what that future tax is going to be. And you could just adjust at closing, even though it's not technically due yet. If there are any issues, any judgments, liens, we can, as long as they're satisfied at closing, you can do so. You don't need to pay them upfront from the seller. Paragraph 21 talks about title insurance. So believe it or not, this paragraph says that the buyer's attorney could actually order a title search right here. Paragraph 8A it says that after they receive a mortgage commitment. So believe it or not, some attorneys out there wait to order a title search until after their client receives their mortgage commitment, which, as we said before, could be 30 or 45 days into the contract. We don't do that. As soon as the buyer signs the contract, we order title. We want to be proactive instead of reactive. And there's zero reason whatsoever, in my opinion, as to why a buyer's attorney wouldn't order a title search. Some title companies charge cancellation fee for any work that's done. It's like $350. And most title companies, I don't want to speak out of turn, will absorb the cost and not charge the buyer in the event the transaction falls through if you do enough volume with them to make up for it, right? Because that would be the buyer's attorney's concern is if the deal's canceled to the mortgage commitment, they don't want to hit their client with a $350 fee for the title cancellation. But in reality, mortgage declinations are few and far between, and title companies, if you're doing a high enough volume with them, may or may not charge a cancellation fee. All right. Paragraph 22 talks about affidavit you're just going to sign at closing that they refer to as a good guy or good gal affidavit. You have no liens, judgments, bankruptcies, foreclosures, and you see no reason why you can't sell the property to the purchaser. Paragraph 23 talks about defaults and the type of defaults and what happens if either party defaults. If the purchaser defaults, then the seller would be entitled to their down payment as liquidated damages. What liquidated damages means is that it would be impossible for the parties to figure out how much the seller has been damaged. So it's agreed upon beforehand that the down payment shall suffice due to that misunderstanding. If the seller defaults, then the buyer has to take them to court and sue them for what's known as specific performance. It's the thought process behind it is you're not buying Google stock, of which there's practically an infinite amount of, and they're all pretty much the same. When it comes to a home, this home is one of a kind. And if the buyer wants that badly, then they'll take them to court over it. And those are the defaults. Paragraph 24, in essence, what this says is that the down payment is deemed to be a pseudo lien on the property, and the seller can't sell the property to anyone else once they're in contract. All right. Paragraph 25 is the method in which the parties must communicate with one another. Traditionally, nowadays, you'll see emails, so we would add that in here. You know, this contract was drafted so long ago before the advent of like texting as prevalent as it is today. So you're not going to see that the parties can communicate through text. If it's something really important, the parties should do so through some type of certified trackable mail where signature is required. It personally drives me nuts when we have a contract and the buyer's attorney sends it to us via regular mail, which takes forever, especially when there's certified funds included, because there's no way to potentially track that. 26 talks about that the buyer can't assign the contract to anyone else. Usually, if it's an all-cash transaction and the buyer wants to put the property into some type of corporation or LLC, you'll add in language that they can do so here, provided that the buyer is the primary owner of the new corporation. So for paragraph 27, it's an important paragraph for you real estate agents. This is where your names would be inserted here. It says that the parties have a separate agreement as to who is going to pay which agent. If you are a buyer's broker and you are receiving more than what MLS has put out offered to you, for instance, they put out 2 to any buyer or selling agent, and you are receiving 3%, this is where the parties have a miscommunication of how much the seller is netting and how much the buyer is to pay out of pocket for their own agent. If you are a buyer's broker, and if you are receiving 3% and only 2% is paid out through multiple, it should be specifically inserted within this paragraph that the seller is paying X amount to the listing agent, they're paying 2% to the buyer's broker per MLS, and they're also paying 1% to the buyer's broker. Because again, if you're a buyer's broker and you have a 3% agreement with your client, the seller has no privity with that. And they may not be aware, even though it's clearly written on your sales agreement, that they're to pay 1% out of the net to you, which in essence, the buyer is including with their offer. That's not stated anywhere within this contract. And it actually goes on to, in the next paragraph, say that any previous agreements, such as your sales agreement, even though it uses the terminology binder, it specifically says it's subject to attorney approval, and it means absolutely nothing in terms of the party's actual obligations. So if you're a buyer broker, or even if you're a selling agent, you have to make sure that your name is reflected within this contract. Otherwise, you're literally having your clients sign off by stating that they haven't worked with you, which is obviously a problem. All right. So paragraph 28, there's a lot of miscellaneous paragraphs here. So in paragraph 8, it says that any verbal or other communications are null and void, and that there's no hidden agreements, and that everything else that is an understanding between the parties actually is included with this contract. All right. Paragraph B says that nothing can be waived except in writing. C, these are all ministerial things between the attorneys. It's singular and plural mean the same thing. It's the same thing with gender identifications, that if they use something in one specific way, that it's also deemed to be the other, so there's no misunderstandings. D, that the paragraph headings over here don't necessarily indicate anything, and the actual verbiage itself. Paragraph E, again, both parties have to sign the contract, needs to be delivered to the buyer's attorney. Paragraph 28F has to deal with the IRS, and if there's any capital gains due, that's where you see the 1099s. That'll be in paragraph 28F. Usually that's handled by the lender's attorney. However, if not, then the seller's attorney has that obligation to file with their client. And it also says that from time to time that the parties may acknowledge other future documents if agreed to at that time. In paragraph H, it's expressly This contract is only for the parties that are mentioned herein. All right. So this is where the normal boilerplate contract ends. However, it was literally drafted at least 20 years ago, and it doesn't have some of the newer methods in the real estate realm. So I'm just going to talk about those now while we continue on. So something else, and this is where you'll see other provisions in a separate rider, where the buyer's attorney would review whatever the custom seller's attorney has drafted. So one thing that you'll see in here is a termite inspection. That's where, usually nowadays, the home inspector will have conducted that as part of their due diligence. And if not, then the seller will give the buyer an opportunity to do so after the fact. Again, usually it's conducted with the home inspection. If there's any live infestation, that's usually the threshold for the seller to have to either provide a warranty or fix any damage that's within the property. Evidence of old infestation doesn't usually give rise to the seller from having to fix anything, because on Long Island, like every house on Long Island has had termites in the past. The other thing to take into consideration is when you're conducting a termite inspection is that it's seasonal, right? When it's freezing cold in the winter, there's traditionally no termites. If there's a seller's concession, you're really going to want to add that, scrolling back up to paragraph 3 over here. With a seller's concession, that's where you've grossed up the purchase price because the buyer wants to finance their closing costs. That needs to specifically be stated in paragraph 3. It also needs to go on to say that if the house doesn't appraise for the grossed up purchase price, so for our example, let's say you're buying a house for $400,000 and there's a 6% seller's concession, the purchase price would then say $424,000. It should also say that if the house doesn't appraise for $424,000, but as long as it appraises for $400,000, again, the original net to the seller, then the buyer still needs to proceed. If the buyer can't proceed because they don't have money for closing costs, that should be determined upfront. Okay. Next, another provision that we like to add is when you scroll back down to paragraph 12, that the parties should have rights to inspect the property. And then when you scroll down to paragraph 16E, that it's going to be broom clean and vacant. Well, sometimes it's not. For instance, about 50% of our clientele are selling, but they're also buying. So it'd literally be impossible for them to give the keys to their buyers at their own sale one morning when they haven't purchased their new home, nor have they had time to remove their personal possessions from the house they just sold to the house that they purchased. So you'll see in paragraph 16E that the seller's attorney will carve out what's known as post-closing possession. It'll state for how many days. It'll also state how much money will be held in escrow, which is usually relative to the purchase price. It'll also say that all adjustments, tax adjustments, and mortgage interest will be calculated as of the date of possession. So that way it doesn't financially cost the buyer any money. They're being compensated. It doesn't cost the seller any more money rather than they normally would have carried, because every day they have to pay taxes and interest on their mortgage if they have a loan still on their property. It'll then go on to say that there's a penalty per day if the seller fails to vacate on or before whatever the possession date is. Clients commonly think that that's a rent. It's not a rent. There's no landlord-tenant relationship here, because those types of parties have a separate agreement and different rights. The dollar amount that is contained in a post-closing possession is just a penalty. It is not the daily fee. The penalty is on top of the daily fee, which again is calculated by the per day taxes and the per day interest. Next, we would usually attach a lead-based paint disclosure to the contract. I know real estate agents, it's required for any house that has been constructed prior to 1978, which is when they stopped manufacturing lead-based paint. So we would attach it to the contract as well. Then you have the Property Condition Disclosure Act. that is as something new that has been conducted since this contract was drafted. So what the property condition disclosure says is that the seller has two options. Again, it's the seller's right. It has nothing to do with the buyer's preference. The seller must either give a lengthy questionnaire detailing every single aspect of the home. And if they don't, then the penalty for that is that they have to give a $500 credit. Again, it's non-negotiable as to the amount. In the actual questionnaire, if they went that route, they would answer questions as to the condition of the home. It was either they know something about it, they don't know something about it, or they're unsure. However, based upon the varying statutes of limitations, your seller could be on the hook for something if they find out, the buyers find out that the seller did know something about an issue that pertains to the home. There are attorney advisory opinions out there that says that if you as the attorney allow your client as the seller to sign this property condition disclosure, that is paramount to malpractice, because nobody in their right mind should be signing that. However, clients, if they are of the opinion that that's in their better interest, or have that right under the law. All right, next is tax grievances. So in the state of New York, it's very common nowadays for the property to be have some type of tax grievance on it. It's important to note this beforehand, because usually when there's a tax grievance in place, the time frame for which they needed to apply, the sellers needed to apply, is already passed. So it's only in the buyer's best interest to move forward with whatever tax grievance the seller already has in place. However, it should be fully disclosed up front, because what will happen is we close, and then the seller gets a bill for tax grievances that benefited the buyer. The buyer says, I don't want to pay any of this. I don't really understand what's happening here. So if there's a tax grievance in place, this should be fully disclosed beforehand. There's also documentation that needs to effectuate the transfer. So one other thing that we need to discuss regarding the contract is solar panels. It's very prevalent nowadays, and it holds up a lot of closings because the solar companies aren't as efficient as they should be or responsive as they should be. If there's solar panels within the property, that transfer process should be initiated instantaneously from when the contract is executed. If not, get the ball rolling beforehand, because otherwise, if we don't know about this and we get the title report, which has something known as a UCC1 against the property, it then may delay the closing. So if you have solar panels on the property, that should 100% be disclosed beforehand. Otherwise, again, it could potentially delay the closing. I hope you guys have found this to be informative. I know I mentioned that we're going to have other classes that delve into more specific areas of law. I hope you look forward to checking those out as well. If you have any questions about any of the things that we discussed, our contact information is below, and we look forward to seeing you and your clients on the next real estate transaction. Take care.